She was brutally assaulted, thrown out of the stairs, and the parents were to pick her up, took her to their shelter.
Who is the petitioner in MC?
He is the husband.
Husband.
And I have also filed an application under Section 9 of the Hindu Marriage Act,
Restitution.
seeking for restitution of conjugal. The petitioner filed for divorce on the grounds of nullity due to non-consummation of marriage. Initially, Xerox copies of the documents were submitted with the petition. Subsequently, authenticated data, images, messages, audio and videos from respondents' phone numbers. It is only such authority or agency or officer or department can certify whether a particular electronic device is in fit and proper condition, whether the materials have to be produced before the court can be accepted. These are all the facts which are required to be
serious allegation of adultery and all. We have some electronic records. Now we have, in the petition also, we have stated all these things. In support of those documents, we have produced it.
How can you yourself get a report if it is fixed for the court?
Your Lordship, from the mobile, I have taken printout.
It is my mobile. How he can take the printout and other things from my mobile unless I authorize him to take it? How this past case has
How
been
can it be?
treated?
Whose instrument is that?
Because the instrument is purchased by me only,
Used by her.
used by her.
Yes.
For the petitioner,
What is this order?
2 applications have been filed under Order 7 Rule 14, seeking permission of the court to produce electronic devices as evidence and stating that some expert has certified those as the correct materials and he wanted to produce the documents. Now the point is this: petitioner is the wife. Their marriage was performed on 4/2/2021. 4/2/2021 is the marriage.
Yes.
She was thrown out of the house in the month of June 2021. That is on 18/6/2021. Within a short span of 4 months. She was brutally assaulted, thrown out of the stairs, and the parents were to pick her up, took her to their shelter. A complaint was filed to the jurisdictional police against the atrocity. Now, incidentally, I may bring to the notice of the court, the father of this respondent is and was an inspector in the police department. He managed to see that the complaint is not registered. By force, they took another complaint, registered as a complaint with a lower intensity. And they submitted the report to the court. That is the subject matter of another dispute. Now, to take revenge, he files a petition.
Please come to the impugned order so that it will be better. The court can
Yes.
appreciate what you are saying.
Yes.
Yes.
Now, kindly see the application that has been filed.
No, before that we'll just see the order, then it
I will read the order.
Yes.
I will read the order.
Yes.
The order is at
Page number 119.
page 116 it starts, and the page 119, order on IA number 4 and 5. Petitioner has filed application under Order 7 Rule 14, read with Section 151 of the CPC, seeking permission to produce documents for marking the same. In the
Who
accompanying,
is the petitioner in MC?
he is the husband,
Husband.
and I have also filed an application under Section 9 of the Hindu Marriage Act,
Restitution.
seeking for restitution of conjugal rights. Both are pending. In the accompanying affidavit is stated that the petitioner filed for divorce on the grounds of nullity due to non-consummation of marriage. Initially, Xerox copies of the documents were submitted with the petition. Subsequently, authenticated data, images, messages, audio and videos from respondents' phone number so-and-so were obtained from a forensic expert, Mr. Panindra, under Section 5 of the Indian Evidence Act 1872. These documents are crucial for the case and are admissible under Section 3 of the Indian Evidence Act. Additionally, the respondent had filed a petition against the petitioner and his family, resulting in crime
At
number.
what stage this application is filed?
Which application?
This application at what stage it is filed?
They have been allowed.
At what stage it is filed?
Yes, at the stage of consideration of the application for payment of interim maintenance.
Mm.
At the stage of consideration of the application for interim maintenance, the learned judge of the trial court went on adjourning the matter day after day without taking that application, and even after arguing, the matter was reserved, and ultimately after long lapse of time, an order came to be passed ordering for payment of ₹5,000 per month. Be that as it may, I'm not on that point. Now, at this stage, application was filed seeking for production of these materials on the ground that they are electronic devices, and they have been produced before the start to be produced before the court. I filed objection stating that this is not permissible because the person who claims to be the expert, he is not an expert and he has no experience at all, and he is not a person as required under Section 79 of the Information Technology Act. So therefore, that application was not maintainable. That was my objection filed. The learned judge has passed this impugned order. Kindly permit me to take page 120. Heard and peruse the material on record.
Yes,
Paragraph 6 I am read.
yes.
I have perused the entire material on record. On going through the materials on record, the petitioner has filed his petition on Section 12 of the Hindu Marriage Act. The respondent has also filed the petition on Section 9 of the Hindu Marriage Act and the same clubbed together. When the matter is posted for petitioner's evidence, it is at stage that the petitioner has filed instant application for production of documents. It is to be noted that as per Order 7-14-1, petitioner will have to produce documents at the time of presentation of petition, and as per Order 14-3 of the CPC, when a document sought to be produced in court by the petitioner, when the petition is presented and the documents mentioned in the list is not produced along with the petition, he cannot produce the same without the leave of the court he received in evidence on his behalf at the time of hearing of the
Yes,
suit.
I have seen.
Now, my submission before this honorable court is this. Under Section 79A of the Information Technology Act.
Yes.
45.
Hmm?
It's to 45.
Before that, I will take the honorable court to Section 45,
It's to 45.
45, 45A and 45 of the Evidence Act. 45 and 45A of the Evidence Act.
Yes,
Opinion of experts.
yes. Yes, please read.
Yes, please. When the court has to form an opinion upon a point of foreign law, or of science or art, or as to identity of handwriting or finger impressions, the opinion upon that point of persons specially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impression or relevant facts. Section 45A. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital forum, the opinion of the examiner of electronic evidence referred to in Section 79A of the Information Technology Act is a relevant fact.
Yes,
Now kindly go to Section 79 capital A of the Information Technology Act.
section?
79 capital A.
Yes,
Central government to notify examiners of electronic evidence.
Hmm.
The central government may, for the purpose of providing expert opinion on electronic forum evidence, before any court or authority specify by notification in the official gazette, any department, body or agency of the central government or state government as an examiner of electronic evidence. It is only such authority or agency or officer or department can certify whether a particular electronic device is in fit and proper condition, whether the materials have to be produced before the court can be accepted. These are all the facts which are required to be taken. The learned judge does not look into this aspect of the matter and mechanically passes the order allowing the applications. So I am before this honorable court challenging the order passed on IA number 4 and 5.
Yes.
Your Lordship, my first submission is the father of the respondent number 1 is not an inspector. He was working as assistant,
that's not
assistant
relevant.
sub-inspector. He was retired prior to the
It's
marriage.
not at all relevant on the merits of it, please
Your
submit.
Lordship, now the learned trial court has allowed the application. He can take all the objections to the before the trial court. There is absolutely no necessity to come before this honorable court to say questioning this order. Your Lordship, this honorable court has also issued direction to conclude the matter within 4 months. They are not cooperating, but there is a serious allegation of adultery and all. We have some electronic records. Now we have in the petition also we have stated all these things. In support of those documents, we have produced it. Therefore, this writ petition has to be dismissed, Your Lordship.
Please come.
And the case is at the initial stage. Evidence not yet commenced.
Please come.
It is not that I am coming in the way of the court, it is causing. In fact, the learned judge of the trial court went on adjourning as I submitted from day after days, and ultimately application for interim maintenance, the learned judge took nearly about 2 years and to pass an order. I am not responsible for the delay. My friend making an objection before the court stating that
Yes. How can you yourself get a report if it's for the court?
Your Lordship, from the mobile, I have taken printout.
No. When you have to file, though you under which provision that you have taken that?
65B, Your Lordship.
admittedly it is my mobile. How he can take the printout and other things from my mobile unless I authorize him to take it? How this false case has
How
been
can it
treated?
be?
Your Lordship, because the adultery committed by her,
No, but the phone belongs to her.
please, Your Lordship.
How will you, like, that's her phone number. The device is with her.
Please, Your Lordship, in the matrimonial tie, Your Lordship, these kind of things cannot happen because she cannot do whatever she wants in
But
such a way.
there is a procedure for everything. That certificate and a 65, who has to give? Whose instrument is that?
Because the instrument is purchased by me only,
Used by her.
used by her.
In this case, this court having heard the counsels on either side peruse the material on record. The electronic evidence which he wants to produce is from the phone of the wife, which she has been using. No, at this stage, the application and the court, there is no whisper in the entire order about that belongs to, the phone belongs to whom. And how that is in the possession of the husband, and other issues are not at all decided by the court. When the phone belongs to the wife and she is in possession of it, and how come the husband had all these the photographs and other whatever the electronic evidence that he is referring to, nothing has been discussed by the court. The considered opinion of this court, just like that, allowing an application and basing on the certificate that is obtained from an expert by the husband, the court cannot just like that allow the applications. In that view of the matter, this application, this IA number, the present impugned order needs to be set aside. It is left open to the parties to come at an appropriate stage to come up with an appropriate application, and in that application, the court shall decide the same.